Okay, so let's say you are in an employment contract, but your employment contract has a restrictive covenant or a non-compete clause, but you're thinking about leaving the company you're working for and either going to work for perhaps a competitor or maybe even trying to start your own business in your trade. But you've got this restrictive covenant and you're being told two different things. Your employer and certain people are saying, well, if you go and work for a competitor, you could be sued, you'd be in breach of contract, you're not allowed to do those things. But on the other hand, you'll speak to other people who say, that restrictive covenant, yeah, it's not worth the paper it's printed on, and you're unsure. Well, in this video, I'm going to explain those things. I'm going to answer the key questions. I'm going to tell you what you can and cannot do. If you haven't seen our channel before, we do videos aimed to help employees. And that's employees either in employment or those seeking employment. The purpose of our channel is to give you things in a real, honest light, cut through the nonsense and give you the truth behind it all. If you like the sound of this content, do consider subscribing to our channel. And if you do, don't forget to click the bell icon so you don't miss any one of our forthcoming videos. Firstly, why have I got any experience in this? Am I a lawyer? Can I give you legal advice? Well, look, I'm not a lawyer, I'm not a legal advisor or anything like that, but this is a subject that I know quite a lot about, for the simple reason that I've been in a position where I've been on both sides of the fence. My job is I own a recruitment company. I used to work in a senior position for a previous recruitment company where I was a regional manager, and I had a very strict restrictive covenant with a company, and I'm not naming them, but it is pretty watertight in terms of what they can and cannot do, and they will be quite aggressive about pursuing people to make sure that they uphold and adhere by that contract, and that is within their right. But also, I'm in a position where my own company, we have restrictive covenants on people, but I'm not too afraid about giving out public advice on it because I know what we can do and what we can't do, and I prefer to be pretty transparent with my staff. If they want to go and work for someone else, these are the rules that they can and cannot do. Simple as that. That's how it works. But when I was looking to leave the previous company, I wasn't sure of whether I wanted to work for a competitor or go on my own. So I was having to face up to this restrictive covenant of what I could do. And my previous company did get in contact, did send me some legal letters, and did try to go down that route. So I really needed to know what I was talking about. So this is a very similar situation to what some of you who are watching this may face at some point coming up. It really depends on a few factors. The first thing I would say is what level in the business that you're leaving are you? If you're a junior employee, and by junior employee I mean you've been there less than 2 years and you're in a non-management, non-supervisory role, I can't find any examples, and I know why you can't find any examples of a company successfully suing a junior employee. A court of law probably wouldn't allow a company to pursue it even if they tried, simply because it wouldn't be seen as in the best in public interest or in legal interest. You want to talk about trying to sue the little man or the little woman, that's the instance. They're a junior employee, they're no real threat to the big company, they're very minuscule in terms of potential losses. So although on paper it is a breach of contract and you may get threatening letters if you were to go out and work for an existing employee, the reality of it is the level you're at is quite low. However, if you're a mid-level or senior level employee, and the more senior you are within a business, the more then that an employer can successfully take you to court. But with working with existing clients, there are two things you need to be made aware of. In the clause itself, there'll be a post-termination restriction, which typically lasts between 6 to 12 months. So in your contract, what a post-termination restriction is it will say you cannot work with any client that you have had material contact with within a set period for 6 months or 12 months from the date of your official last day with the business. And that means for that period, you can't have any contact, you can't solicit them, anything like that. And if there is any material evidence, and by material evidence in legal terms, this means any documented evidence, paper trail, email evidence, telephone call trail, recorded conversation, text, anything like that that could be presented as evidence to demonstrate that you have tried to either solicit business or that you're actively working jobs or working client accounts. And this goes for, it doesn't have to be recruitment, bear in mind, this can be legal, sales, account management, anything like that. If an existing client contacts you and you want to contact them back, typically what I would do is I would write them an email, a polite email saying, look, due to contract restrictions, I'm not allowed to work with existing clients for this set period. I wouldn't go on to say any more than that, but contact me at the end, because that could be seen as solicitation. But as long as you're notifying them that you cannot work with them for a set period, only if they contact you, that's fine, because you're just stating the reasons. That's reasonable for you to be able to do, but you can't be seen to solicit business from them. The other thing you want to be aware of is the period that it is effective from during your employment. So what I mean by this is there's a post-termination restriction, which means from the date of you leaving, you cannot work with an existing client for 6 to 12 months. And then there is a pre-period before that, which basically qualifies what is consisting of an existing client. So that means any client that you have had, again, material contact with for 6 to 12 months before you left employment. So if there is a paper trail, email, text, calls, anything like that, of you dealing with a client actively, and that means not only anyone who is your client, but if you're in a managerial position, any clients that belong to people that are your subordinates, then that would be classed as you having had some material contact with them. Because you'll know the client, they'll go through the business, you'll oversee it, all that kind of stuff. And a court could take that into account and say, well, you knew who these companies were, you knew the contacts, and you have used that to take business away from the client that is suing you. So if you are a specialist within a particular area and you want to leave your company and then go and work for a competitor of that company working in the same marketplace, or you want to start your own business within the same sector, these clauses, these restrictive covenants, these non-compete clauses, they will typically say for a set period, say 6 to 12 months, you cannot be employed with a competitor in this sector. Some will say you cannot work with an existing competitor within a 1 or 2 mile radius, and some will just say blanket, you cannot work within the same marketplace. The idea of it being that would be competition. It's typically worded as a non-compete. So by you going out and leaving the existing company, you would then be a threat to them by working for another company in the same sector. And this is something that they say that can be enforced. The reality of this is typically no, it cannot be enforced. It's very, very unlikely that it's going to be enforced in any way. And I haven't found any examples really of it actually being enforced. And this is for 2 simple reasons. Firstly, any employment contract has to be seen to be fair and reasonable if any of those clauses are breached, and therefore that the employer wants to go and charge or take that person or prosecute or attempt to prosecute that person for breaching those clauses. Basically, on a restrictive covenant, you'll have a bunch of things that it says you cannot do. But some of those aren't really worth the paper they're printed on, because if they cannot be enforced because they would be considered not fair and not reasonable in a court of law, it won't even make it to a court of law. They wouldn't even take any notice of it. They'd laugh it out of court, to be honest with you. And this is one thing that I'm asked quite a lot about. But there is another reason, and this is a specific law of why you can't stop someone going and practicing their particular trade. So if you're a plumber, for example, a plumber's company that you're working for can't say, right, you can't be a plumber for 6 months, because that's your trade. And it's something called the Competitions Act. The Competitions Act itself was basically brought in to stop monopolisation of a particular sector or particular industry by any one company. You cannot restrict fair competition in the working marketplace because it hinders growth for the country. So the Competitions Act puts a stop to all of that. So even if you work within a very specific niche, let's say you are like me, an engineering recruiter who looks after, let's say, manufacturing, you can't just say, right, you can't do manufacturing engineering recruitment for the next 6 months. For the simple reason that's your trade, that's what you know. I don't know education recruitment, I don't know accountancy recruitment, I cannot go and do that. So if I left and I went to work for an accountancy recruiter or an education recruiter, the chances are I'm not going to be paid the same amount of money that I'm being paid to be an engineering recruiter, which is my trade. Therefore, I would lose out money and it would hinder me being able to get on my life. Ultimately, though, that's going to hinder the competition, and that goes against the Competitions Act. Now, some companies, my old employer being one, did send threatening letters. They sent threatening letters to me when I left, and they sent threatening letters to staff that had left, that we had hired after my restrictive covenant had expired. So for example, a couple of the guys that worked at that company came across to work for me, but I'd been out of the company long enough for my restrictions to have expired, and they sent letters to them. And by threatening letters, let me clarify what that means. They didn't send me letters themselves, they had their lawyers send me letters. And the way these letters are constructed is they will say along the lines of, we suspect you have breached this clause, we have reason to believe you have done this. All of these things which are implied, they're not direct accusations, but they're getting on that. They're suspect accusations. And they're basically designed, if nothing else, to really put you off and frighten you up and think, right, they're serious if I try to do anything wrong. But realistically, you have two options. You can either ignore these letters. And in legal terms, if someone sends you a letter from a lawyer threatening you for something or pre-warning you or something like that, and then demanding that you go and reply to them with a 6-page document documenting everything you've done and all these things to prove your innocence, you do not have to do any of these things. They could send you 20 letters. Unless they can take you to court and it's a court order saying you have to do this, you don't have to do anything. You can, though, if you want, reply to these letters. Now, typically speaking, I would generally advise, unless you really know what you're doing, to go and take legal advice, which I'll go through how that works briefly in a moment. But realistically, these letters, unless you've done anything wrong, ignore them. And unless they're taking you to court and have then summoned you to court or have put a legal injunction to you because of some form of evidence that they have that says you cannot do your trade until pending an investigation, then realistically you don't have to do anything to these letters. Now, a quick bit on taking legal advice. Legal advice itself often is a bit of a waste of time unless you're actually going to court. If you want to reply to certain letters and they're accusing you of something, then you probably want to take some legal advice. But generally speaking, unless you're actually going to court, I wouldn't bother taking legal advice. It's not really worth it. It's quite an expensive thing and they're just looking for a bit of money out of you. Many of these lawyers, in the nicest way, solicitors, a lot of the time, they just want the billable hours. They can give you really basic advice. So unless you're actually being taken to court, unless you're actually being sued, unless you actually have to give a response to these letters because a court has asked you to do so, I wouldn't bother taking legal advice. That's my personal advice. That's not, you have to do that, but that's what I would recommend you do. I don't think it's worth pursuing unless you're actually being taken to court, unless you've done something wrong. So hopefully I've given you the answers to the key questions there you probably want to know. However, you may have other questions. If you do put them in the comments below. It is a subject I'm pretty knowledgeable on. I could probably talk about it for England, to be honest with you. So if you did need to know anything, put them in the comments below. I would do my best to come back to you as quickly as possible. But I get asked this stuff quite often, so I thought I'd do a video on it. If you like the content you saw today, do give us a like and subscribe to the channel, and hopefully we'll see you for the next video. Check out our other videos as well. You'll probably see some links through this video of our other bits of content. So thank you for watching, and we will see you for the next one.